While the Arizona Civil Rights Act and the Federal Fair Housing Act generally prohibit discrimination in housing and advertising, both laws recognize certain exemptions that allow for specific housing programs to serve unique populations. These exemptions are narrowly defined and carefully regulated to prevent misuse or unintended discrimination. In Arizona, exemptions for housing of older persons, accessible housing, and affirmative marketing programs are governed by the Arizona Civil Rights Act, ARS Section 41-149, 1.04 through Section 41-149, 1.08, and the Federal Fair Housing Amendments Act of 1988. Understanding these exemptions helps real estate licensees apply the law correctly and distinguish between lawful specialized housing programs and unlawful discriminatory practices. The first major exemption applies to housing for older persons, which allows certain developments and communities to legally restrict residency based on age without violating fair housing laws. Under ARS Section 41-149, 1.04, and the Federal Housing for Older Persons Act, HOPA, housing may be lawfully designated as age-restricted if it meets specific requirements. The most common categories are communities intended and operated for residents who are 55 years of age or older, or 62 years of age or older. To qualify for this exemption, the community must demonstrate that at least 80% of occupied units have at least one resident aged 55 or older, publish and adhere to policies demonstrating intent to operate as a 55-plus community, and verify residents' ages through reliable documentation every 2 years. For example, an active adult community in Sun City, Arizona, that clearly states in its recorded covenants, conditions, and restrictions, CC&Rs, that it is a 55-plus development and verifies resident ages in compliance with HOPA requirements, is legally exempt from familial status discrimination claims. However, this exemption does not allow for discrimination based on other protected characteristics such as race, color, religion, national origin, disability, or sex if an age-restricted community refuses to rent to a qualified applicant because of ethnicity or disability. It still violates the Arizona Civil Rights Act and federal law. The second exemption concerns accessible housing, which permits the construction, advertisement, and operation of housing that is specifically designed for individuals with disabilities or mobility limitations. Under ARS Section 41-149, 1.19, and 42 U.S.C. Section 3607B2, it is lawful to advertise or design housing intended primarily for persons with disabilities, provided the program or development meets accessibility standards and is consistent with the objectives of fair housing laws. For example, a newly developed apartment complex may advertise units as fully accessible for residents with mobility impairments, or featuring ADA-compliant bathrooms and ramps. These advertisements are not discriminatory because they describe the property's accessibility features rather than excluding others. However, it is critical that licensees avoid language that implies exclusion, such as only for disabled persons or restricted to those with physical impairments. The law permits the marketing of accessibility features, but prohibits restricting access to housing solely to individuals within that group. A compliant statement would focus on the property's amenities and design, not the characteristics of its potential occupants. For example, units designed to accommodate wheelchair users is lawful, while housing reserved for wheelchair users would be a violation. The third exemption involves affirmative marketing programs, which are proactive outreach efforts designed to ensure equal housing opportunities for groups that have historically faced discrimination or barriers to access. These programs, authorized under ARS Section 41-149, 1.25, and the Federal Fair Housing Act, allow housing providers, developers, or government agencies to target advertising and outreach toward underrepresented populations without violating anti-discrimination laws. For instance, a city housing department might conduct an affirmative marketing campaign to encourage minority families or veterans to apply for affordable housing programs. Because the intent of affirmative marketing is to promote inclusion and expand access to housing, such programs are exempt from discrimination laws as long as they are implemented in accordance with fair housing objectives and approved by relevant regulatory authorities. A real-world example of affirmative marketing can be seen in federally assisted housing developments that must follow HUD's Affirmative Fair Housing Marketing Plan, AFHMP. These plans require developers to actively market units to groups least likely to apply, such as racial minorities, families with children, or individuals with disabilities, depending on the local housing context, by advertising in diverse media outlets, offering materials in multiple languages, and engaging community organizations. These programs help ensure equitable access. In practice, licensees must exercise care when representing or advertising properties associated with these exemptions. Misrepresentation of a property as age-restricted when it does not meet the statutory requirements or describing housing as for disabled persons only could result in violations of ARS Section 41-149, 1.22, and ARS Section 32-2153, AA3. Brokers are responsible for ensuring that all advertising accurately reflects the property's lawful status and complies with fair housing and ADRE rules review summary. The Arizona Civil Rights Act and the Federal Fair Housing Act recognize limited exemptions for specific housing types: age-restricted communities, accessible housing, and affirmative marketing programs. Housing for older persons is permitted when operated in compliance with ARS Section 41-149, 1.04, and the federal HOPA standards, requiring at least 80% occupancy by residents aged 55 or older, and written policies showing intent. Accessible housing programs may advertise features for disabled persons without excluding others. Affirmative marketing programs, designed to promote inclusivity, are lawful when used to expand housing access for underrepresented groups. Misuse or misrepresentation of these exemptions, however, constitutes a violation of both ADRE and fair housing regulations. Discussion: why are age-restricted communities considered lawful under the Arizona Civil Rights Act? Answer: because ARS Section 41-149, 1.04, and HOPA allow housing for older persons if it meets federal occupancy and policy requirements, while still prohibiting discrimination based on other protected characteristics. How can a real estate licensee advertise accessible housing without violating fair housing laws? Answer: by focusing on the property's features, ADA-compliant design, rather than restricting who may live there, only for disabled residents. What is the goal of affirmative marketing programs in housing? Answer: to promote inclusivity by reaching populations historically excluded or underrepresented in housing opportunities, consistent with ARS Section 41-149, 1.25, and HUD's fair housing objectives. Closing remarks. Fair housing exemptions exist not to limit equality, but to enhance it through targeted, lawful, and inclusive housing opportunities. Whether serving older adults, individuals with disabilities, or historically underrepresented communities, these exemptions reflect Arizona's commitment to balancing freedom of choice with social responsibility. For real estate professionals, understanding these distinctions is essential to ensuring that every advertisement, communication, and transaction aligns with both the spirit and the letter of the law. Upholding these principles not only fulfills a legal obligation, but also reinforces the integrity and fairness that define the real estate profession.